Shops versus Brothers Petroleum.
Good morning, Your Honors. Peter Hall on behalf of Appellant Cross Appellee of the Paradies Shops.
I'm sorry, I mispronounced it.
No worries at all. The central issue on this appeal, Your Honors, is the process used by the district court to get at the fundamental question in the case, which is whether the parties ever, through offer and acceptance, reached a meeting of the minds to enter a contract containing an arbitration clause. Congress has spoken to what that process should be in Section 4 of the Federal Arbitration Act and stated that the process must be a trial. In this case, however, not only was there no trial held, the district court entirely abdicated its responsibility as a fact finder by holding that it was precluded from reweighing the evidence on a motion to confirm or motion to vacate. So how did we get into that posture? Because like another fairly recent Fifth Circuit case, Imperial Industrial Supply versus Thomas, we got into a situation where one party and an arbitration organization or an arbitrator were willing to go forward with the arbitration even though the other party objected that no arbitration agreement had ever been created. And
how did you get in a situation where the district court did not refuse to grant a stay?
So we moved for an injunction under the All Writs Act, arguing that allowing the arbitration to go forward would essentially intrude on the jurisdiction of the district court to make that very ruling. That was denied by the district court.
The district court thought they'd already ruled on it, or what?
On the injunction request?
Arbitration.
So the district court ruled on the injunction request, denying it, saying essentially, I find that a contract exists.
Right.
That was then taken up on appeal, arguing that that would effectively constitute a final judgment. The difficulty is the district court, even if it ruled in a preliminary injunction context that an arbitration agreement exists, that's not the process envisioned by Congress. It envisioned a trial, not a final determination on a preliminary injunction.
It could be a matter of law. You don't have to, if the documents show as a matter of law there was no agreement to arbitrate, you don't have a trial.
I agree entirely, Your Honor, and that's why under Federal Rule of Civil Procedure 81, incorporating the federal rules into the Federal Arbitration Act, if you apply a summary judgment-like standard or some other standard that allows a court to determine that there are no factual disputes and rule as a matter of law, then that could be done without an actual trial. But applying that standard to this case and this court reviewing that decision would have to lead to the conclusion that there are, at the very least, factual disputes warranting a trial. At a minimum, we have a declaration from one party stating, we never intended to extend an offer to contract, and we never intended to be contractually bound. Under Chester versus DiRecTV, that was enough to send the matter to trial. That put the making of an arbitration agreement in issue. It was an unequivocal denial, and a trial was required. And in fact, in the age discrimination component of Chester, the Fifth Circuit noted that it was improper to have ruled on the papers unless they gave the overtime component of that case preclusive effect. So entirely agree that there are ways to not have a trial, but it would have to be some way contemplated already by the Federal Rules of Civil Procedure. The other reason that we need the district court to make a completely independent factual determination of the question, was a contract ever formed, is because it goes back to the court's jurisdiction to make that decision in the first place. As Judge Higginbotham's opinion in the Will Drill Resources case mentioned, the court is the one who decides whether the contract was formed. If the court doesn't make that determination on a motion to compel because the arbitration is going forward anyway, it needs to make the determination independently afterwards, or else we've effectively given the power to decide to the arbitrators. And so in this case, kind of like in Imperial Industrial Supply, we have a dispute, the arbitration went forward, and we needed a judicial decision about whether the contract was ever formed, and that didn't happen at the district court. That's why reversal is warranted here. But as Chief Judge Owen mentioned, we don't believe that reversal and remand for trial is necessarily required in this case. And that's because Paradies, through undisputed evidence, has negated an essential element of the claim on which Brothers bears the burden of proof. In other words, Brothers, as the proponent of arbitration, has to show that an arbitration agreement was formed. To do that, under Louisiana law, they need to show offer and acceptance, and the record evidence shows that there was never an offer made, because an offer has to be a statement inviting an acceptance, something pursuant to which you can become contractually bound. And showing somebody a template or engaging in business discussions or talking about the terms that you would eventually agree to is not inviting an acceptance to result in a contract. Based on that fact, the negation...
What was before the judge on the preliminary injunction hearing that, and more accurately, what would you put before him that was not before him then? What would you now put before him?
Okay, well, what was in fact put before him at the motion to vacate...
Change the title preliminary injunction, but leave it to everything else the same.
Okay, so if approaching the district judge in the first instance without a preliminary injunction hearing, that would come on a motion to vacate or motion to confirm. And the evidence that was before the judge at that stage included the declaration from the general counsel, testimony that was given in the underlying arbitration hearing, documentary evidence expressly disclaiming an intent to contract. And so all of that was before the district judge on the motion to confirm and vacate. It wasn't available yet at the motion for preliminary injunction stage, and a preliminary injunction isn't a necessary prerequisite.
What was before the judge on the preliminary injunction?
I'm sorry?
What was before the judge on the preliminary injunction?
So the agreements themselves, the declaratory judgment petition, so the express, the unequivocal denial of the existence of the agreement was before the judge. The agreements themselves that were unsigned by Paradies and that had been indicated to Brothers that were only offered for review and comment, not for acceptance. But what wasn't before the district judge then was all the additional testimony, because under the All Writs Act, the standard we had to satisfy was showing a threat to the jurisdiction of the district court, not necessarily a likelihood of success on the merits of the declaratory judgment case. And so the basis for that initial motion, which again is not a necessary prerequisite to seeking vacator on these grounds, limited the evidence that was put in front of the district court.
So what do you want? What relief do you seek from us?
We seek reversal of the order granting confirmation and denying vacator. We believe that it would be proper under a summary judgment standard of review for this court to render judgment in favor of Paradies based on the negation of an essential element, but if not, reversal and remand for discovery and trial.
I'm not sure how we could, on the one hand, say there's not enough there, and then on the other hand, say that that insufficiency is determinative. That would give determinative quality to the preliminary injunction hearing itself, albeit going the other direction.
No, on the evidence, based on the burdens of proof, Your Honor, I think the way to view it is...
But we would be making a final decision ultimately on the arbitration availability at a preliminary injunction stage on the state of that record, which of course you say is not sufficient to make a determination of the merits. You say
no, Your Honor. The reversal would be after the preliminary injunction was denied. We're now after the arbitration hearing.
You want to deny the arbitration, of course. You want to set aside the arbitration.
It says grant the motion to vacate because, like in Imperial Industrial, there was an arbitration with no agreement.
So the relief you seek is to vacate the arbitration, period.
Yes, the reversal of the denial of the motion to vacate.
Why wouldn't you wait to see if there's a determination, if there's an agreement to arbitrate before you've vacated it?
Because the district judge entered a final order granting the confirmation and dismissing the declaratory judgment action as
We can remand and say, Judge, decide if there was an agreement to arbitrate, there's a fact question, I mean, hypothetically.
Yes.
And we would say, there's no reason to vacate the arbitration award unless there's no agreement to arbitrate.
I understand the question there. It would essentially, it would be not granting the vacator unless judgment is rendered in Parady's favor. If it's remanded for a determination, the determination goes one way or the other. Either there is an arbitration agreement, in which case we already have the award and we move on, or there is no arbitration agreement and vacator necessarily follows.
Well,
Did y'all file a reconsideration that was invited by the court?
It was it was certainly not invited, Judge Elrod.
I thought it said, Counsel, I never foreclose any party that has received an adverse motion to seek a reconsideration. I'm just reading this, and I've given your opponent till Monday. You know, so if you would, I would say that any motion should come after their response on Monday. He's given timelines for it.
Right, so that was at a time when Brothers hadn't yet filed even an answer to the declaratory judgment. And so I believe you're reading from the preliminary injunction transcript.
Did you try to get that cleared up? At the
We appealed the denial of the preliminary injunction.
Appealed it, yeah.
Right.
You didn't get it cleared.
Right, we didn't ask.
It still seems to be that it was never quite cleared up to the judge.
Right, because when we got back to the motion to confirm and vacate, he said, I don't know why you don't understand. You already lost. I already decided the contract exists. And then granted the motion to confirm and dismissed the declaratory judgment. Our position was he couldn't have done that without either a trial or some sort of summary judgment type procedure.
so I go back to the relief you seek. It seems to me that the most you're entitled to is to go back in that point, to leave the arbitration in place, I mean, for now. But go back and have a full determination on arbitrability.
Yes.
Period, up or down.
Yes.
And if the court determines that you have an enforceable obligation to arbitrate, then you've got your award.
Right. And
In other words, I don't see any deficiency I haven't heard any deficiency in the arbitration itself. In other words, cut through the smoke and get to the procedural flaw.
Right.
I'm not describing our rule report. I'm trying to be clear about what relief may be available or not to you.
Yes, understood, Your Honor. The fundamental relief we seek, reverse the granting of the motion to confirm. Then we need a decision up or down whether the parties ever agreed to enter into a contract with an arbitration. If the answer is yes, there's an award. If the answer is no, then under Imperial Industrial, the arbitrator exceeded his authority and it needs to be vacated.
Okay.
And unless the court has any other questions, I'll reserve the remainder. Thank you.
When Paradies sought their injunction and it went before the district judge, it was heard as a motion hearing, as 9 U.S.C. Section 6 provides, that anything under 9 U.S.C. 3 or 9 U.S.C. 4 is tried as a motion. So it went before the judge as a motion. In their application for an injunction, all they submitted no affidavits whatsoever. They submitted an email from me paying the arbitration costs. They submitted a letter from the American Arbitration Board saying arbitration was ongoing, and they submitted a letter from Ms. Cantrell of the AAA saying that an arbitrator had been appointed. None of that was verified in any way. In response, my client submitted an affidavit with saying what exactly the procedure was they went through, a copy of the license agreement signed by him, a response from the counsel, the vice president and transactional counsel for Paradies saying, we won't sign this now, only when we win. So they are indicating to my client, when we win the bid, we're going to sign this. It's simply a license agreement that said, you can license our logos and our trademark. This is the term of the license agreement. That was all decided. This is the licensing fee. This is how the licensing fee is paid. Every part of that contract had already been decided. That's why my client signed it. When Ms. Suttle says, okay, we're not going to sign it now, we'll sign it when we win. So then they do win the bid in April of 2017. In August of 2017, they signed the lease with the airport. The license agreement runs concurrently with the lease. So you have the agreement in effect. Then attached to the affidavit were all the contacts that went on between Paradies and Brothers Petroleum in the 2.5 years after that, including one that said, listen, we've gone to the airport, we showed them your logo, they're okay with it, they like it, but they want it to look like this, but they're good with it. So all of this was verified by affidavit submitted in connection with the motion. In response to that, Paradies did not file any affidavit, nothing verifying anything.
Counsel,
Yes.
this failure to file the deficiencies, if any, were in response to a motion for preliminary injunction.
I'm sorry?
That was in response to a motion for injunction.
Correct. And one of the requirements in order to rule on that injunction was, is there a contract or is there not a contract? That was an essential.
But it is a preliminary injunction. It's contemplating future proceedings.
Yes, sir.
So your argument would, on its face, appear to convert that into a determinative outcome rather than a preliminary outcome.
Well, when we were in oral argument on, I think it was March the 17th, Judge Lamel asked counsel for Paradies, tell me what is it that you have to show me? What is it that I missed? What do you have now after we went through 488 pages of testimony in the arbitration hearing? We produced everybody's emails back and forth. There were over 1,000 pages of document. What do you have to tell me that the ruling that I made back in 2020 was wrong? Do you have anything to show me? And Mr. Hall could not respond to that. All he could say was, we really didn't make an offer. We never made an offer. Well, I think there's two ways you can look at it. Perhaps by signing the license agreement by my client and sending it to Ms. Suttle and having her respond, we will sign it when we win. That's an offer and acceptance. And it's also backed up by the interactions between the parties after that, after they won the bid. All of the things, taking the logo, applying to the airport, is this okay? This is going to look okay on the...
Maybe, go ahead. Maybe I misunderstood. I thought that one side signed it and then sent it to Ms. Suttle, and then she said, no, we're not going to do this yet. And then they sent a clean, unsigned exhibit back. What do you make of that? Is that what happened?
What she responded was, we won't sign it. We won't sign it now, only when we win. Well, a couple of months later, they did win the bid. So
I'm just saying, I thought one side signed it and the other didn't, and then they said, no, this is just an exhibit, we're not ready to we're gonna negotiate this. So then the side that had signed it sent a clean, unsigned copy back. Is that what happened?
And they sent a clean one back,
Unsigned.
and then Mr. Baque, who was acting as an intermediary for the Brothers Petroleum Company, said to Ms. Suttle, the same day she said, we'll sign it when we win, he said, well, go ahead and hold on to it, and you can sign it when you win. Now, all of that,
It's in effect as soon as it's signed, because they said they want to wait. And
Yeah.
so that they're not, and then there were some things changed too that the airport required, weren't there?
no, there were,
There were some other things going on too. I thought that's in the record, but perhaps I'm wrong. But it's,
no, I don't,
I just don't think that the fact that they sent them a blank one means that they understand that this isn't a done deal yet.
but when you say we will sign it when we win, that's a conditional acceptance of the agreement. He's saying, hold on to this agreement, Mr. Baque, hold on to it. When you win, you can go ahead and sign it. And then from that point, they move forward to interactions with Brothers Petroleum and the airport.
Once they won, and then they would sign something.
But that's the thing. Ms. Suttle is the vice president. She said she's the transactional attorney for Paradies. She says that she's done over 10,000 contracts. And to send back a response that says we will execute it when we win, not we will negotiate further, we'll discuss it, we will execute it, but only when we win. She absolutely did. To a transactional attorney, execute means we're going to sign it.
Though the problem is, there's that about whether factually they had agreed. There's also the problem, though, that procedurally, and we talked about it at some length, that there was never any proper process for summary judgment, or you can't just say, well, what's different now than was at the preliminary injunction, and I'm just going to leave my ruling from the preliminary injunction to be for the summary judgment. There's no proper summary judgment here. There's no definitive ruling by the court. So I don't understand why having a hearing and saying, so what's different, is proper under the rules. There's no evidentiary record for the summary judgment if you believe it's summary judgmentable that you had a contract, right?
I believe based on the record, the 488 pages of testimony and all of the documents, that it's clear that a contract was formed.
And the district court should have granted you summary judgment without the need for an evidentiary hearing. Is that correct?
Correct.
Okay. Well, the district court granted judgment but didn't have a procedure that was a judgment procedure, as far as I can tell. So can you help with that?
I don't think that there was anything that was shown to the court that convinced the court that the earlier ruling on the preliminary injunction was in error in any way.
But that's not how you get a judgment on the merits. You don't just say, well, the thing we did earlier, did they move to accept that record to be the record for summary judgment, and everybody then had a chance to put in some new record facts if they wanted to, and then the court could say, oh, that's not a fact issue. Was any of that done? Or was it just we had a hearing already on this? The district court seemed to treat the preliminary injunction like it was the judgment hearing.
Yes, because...
And that's not correct.
Because of the documentation, I think, that was submitted, or lack of documentation on Paradies' part, that was submitted that said that there was anything, that the only thing they put forward to the court is, look, it didn't get signed.
Normally, I don't think of these in terms of an injunction. Every time, back when I was in practice, it was a motion for stay, and since I've been a judge, it's almost always a motion for stay. A motion to stay arbitration, or, and that preliminary decision is made, and usually that's a final, it's interlocutory, but the judge has made a final determination as a matter of law that there's an arbitration agreement, that the subject matter is covered by the agreement to arbitrate, and off you go. And you can appeal that determination.
Well, you could try to appeal. It's interlocutory, but as this court said when it denied the appeal, it said, look, we're not precluding you from coming back and challenging what the judge determined at that time. Well, in the briefs, Paradies has not challenged that initial ruling at all. And it doesn't submit it as an issue of fact, and it doesn't brief what happened in that hearing and whether the judge's ruling was adequate or inadequate.
It was on appeal. I mean, and they did raise it on appeal.
They raised it on appeal, but that appeal was dismissed, and they were told, specifically, we remind Paradies that appellate relief is not barred completely, only deferred until the end of the arbitration proceeding. Well, when they have briefed it here, as we are in that appellate proceeding, they have not briefed anything about whether the judge was correct in his initial ruling that there was a contract based upon.
They've just done that in the papers in front of us. They're saying there's a fact question.
They're saying the judge made an error at the back end, but they haven't challenged what he did at the front end. The idea that he found that a contract existed.
The court said, we're not going to look at the merits, bring those merits later, which they've done.
Okay.
I mean,
I understand what you're saying. Well, let me get, before I run out of time, is the portion of the ruling, the arbitrator's ruling that was vacated. I don't think that there are any grounds to vacate that ruling, and I think this court can reinstate that, even if you're going to send it back to the district judge, that you can vacate his vacatur of specific performance and damages for which there was no justification to challenge the arbitration ruling. And I think the judge, as we were going through oral argument, consistently said, well, the arbitrator considered this and the arbitrator considered that, and there was no justification.
That begs the question, whether you get to arbitration or not. The simple way to resolve this case, and that would seem to me, is simply that, as we started off, is simply to vacate and go back and send it back down, and now decide on the merits of the question of arbitrability. And if you win, you win, but you don't have to go back to arbitration. You put that in your pocket, but you don't get there until they have an opportunity to do it. Now, if you're correct that they don't have anything else, then you won't have a problem. But there's a serious procedural error here, and granting full relief on the basis of a finding on preliminary injunction. And I'm sorry, but DiRosa, you argue what you got, but I don't hear an answer to that.
Okay. Well, if what I'm saying, though, is if your honors are considering doing that, I don't want to go back with a ruling that vacates the substance of this contract. And then if the court determines that there's a contract, I'm still stuck with a contract that half of it or 90% of it has been vacated by the court's earlier ruling. So, which I think is improper. I think it considered a letter from the airport. It considered many things that it should not have considered in trying to vacate the judgment. So if we're going to go back there, I want a whole arbitration award to take back there to say, okay, if there's a contract, here's the arbitration award in its entirety. You should not have vacated any portion of this. And if you find that there is a contract then that whole arbitration award is valid and good.
Cross appeal. This is your cross appeal.
Exactly.
You're trying to get your cross appeal. You want us to rule for you on the cross appeal today.
That's correct.
And so look at that and okay. And you believe we can do that?
I believe you can, yes. Because his ruling, what you're saying is you're going to go back, you're going to have the arbitration award intact. And you're going to go back to the district judge and say, okay, this is the arbitration ruling that's intact. If you determine that there's a valid contract, that's the arbitration ruling. If you don't determine that there's a valid contract, then all of that goes away and you have nothing. But I don't want to go back and have him say, okay, there is a valid contract, but I'm striking specific performance, I'm still striking damages, then we're going to come back here and say,
If we can resolve those, you would ask that we would do it.
yes, ma'am, yes. I don't think he should have considered the letter from the airport. Impracticability, as far as specific performance goes, is an affirmative defense. It's a defense of avoidance. You can't just, first of all, it was never pled, and second, the burden of proof rests with Paradies, who never called any witnesses to say that it was impracticable, despite the fact that they had an airport witness listed on their witness list. So I don't think the judge had any grounds to even consider this 3-month later letter from the airport saying, oh, well, we really don't want to use Brothers Petroleum. And by the way, just to be clear, Brothers Petroleum as an entity has since been sold to an LLC whose parent company is Mountain Express Corporation in Atlanta, Georgia, so that Mr. Hamden himself is out of the picture. But I just don't want to double up on this appeal. That's because it seems like you all are indicating that we're going to wind up back before the district judge, and if that's the way it is, I don't want to come up here. I know you all would love to see me, but I don't want to come up here a second time and try to argue again about something that we've already argued about as far as specific performance and damages.
I think we're on the same page.
Yeah. Thank you.
What about you?
I'm going to be very short, Your Honor, and that's.
But to the point, you heard the exchanges here with the court. Speak to that.
Yes, Your Honor. So most recently, I want to make sure that I recognize the procedural mess that we're in, and if we had a motion to compel and a determination on that, and then Section 16 has an orderly appeal process, we're completely out of order here. But where we are, it seems the next proper step would be remand. There's a determination about whether an arbitration agreement exists or not. If one exists, then there would need to be new briefing based on those new findings.
Why? If there's an arbitration agreement, then why isn't the arbitration that took place valid? And didn't the district court err because it vacated the arbitrator's award for certain things apart from the reasons in Section 10? It didn't use proper reasons, alleged, is the argument of the other side. And so assuming we agreed with that arguendo, why wouldn't it be proper to say that was incorrect? And so that we don't have a third hearing on this case, or our third, I guess it's second hearing, third appeal.
Understood, Your Honor. And I believe the issue has to come down to effectively whether this panel is going to issue an advisory opinion on what the court should do in confirming the arbitration award, because it has to reverse the confirmation order, and then if the court finds a new a contract was entered, there has to be a new confirmation.
Well, let me ask, could we do a limited remand, keep the case, let the district court decide whether there was an agreement to arbitrate, and then then come back here with the existing briefing?
That would work as well, in which case, Your Honor, I would clarify in response to Judge Elrod's comment that we believe the district court did act properly under Section 10A4 in eliminating specific performance, because the contract is a license, fundamentally. It's a permission to Paradies to use the marks in exchange for pay. It is not an obligation to go hang the signs up, and so ordering a putative licensee to go hang the signs up would be in excess of the authority granted under the agreement. It's as if I asked McDonald's about being a franchisee, changed my mind, and then they sought an order compelling me to open a McDonald's as opposed to any other type of restaurant. And so we think it's completely consistent with Section 10A4 to deny the specific performance of hanging the signs and paying the licensing fee going forward.
You know, Coach Bryant always said that when you're ahead, you don't put the ball in the air.
Wise words, Your Honor.
I thought so.
Thank you.